Welcome to a special episode of Tricks of the Trademark with me, Erik Pelton. On this special episode, we're celebrating our 25th year as a boutique trademark law firm with 25 special episodes featuring 25 tips. Cases before the Trademark Trial and Appeal Board, whether they are ex parte, meaning just an appellant or applicant, or inter partes, meaning there's a dispute between two companies or two parties, can be very, very complicated. There's its own set of procedures and rules, and of course, case law that governs TTAB cases. And what I want to talk about here is 25 key terms or concepts that anyone getting involved in a TTAB case ought to think about, learn about, know about. So first tip is there's a great resource from the board called the FOIA Reading Room, and that is where you can search many past decisions and read some summaries and filter and basically do a lot of research on other TTAB cases. Another great resource for research is the TTA blog, TTABLOG.com, from my colleague John Welch. Great resource with thousands of cases summarized from over the years from the appeal board. Another important tip is to know about the timing and length involved in a TTAB case. Short answer is they're generally slow and long. A dispute with multiple parties can take 2, 3, 4 years. Fourth thing to know about is requesting a hearing. A hearing is optional but can be requested with a fee. And you want to know about the rules and why or when you might think about a hearing. Speaking of fees, fifth tip is to know about the fees related to the TTAB. They're published by the USPTO, but obviously an important consideration in knowing about a case going forward is what are going to be the government's filing fees. Sixth is the briefing and particular rules as to the briefing stage of the case and how long a brief can be and what goes into a brief. Both the substance and procedure of briefing, very important. And to find those type of rules and details, one would look to the TBMP, my seventh tip, which is the main guide that covers all of the procedures and rules for the appeal board, a very important resource. It is very, very lengthy, which is good because it has a lot of information, but finding the right information and getting used to using it and knowing the relevant information takes time and experience. In an ex parte appeal, it's important to know what is an appeal and when does it arise, what is a request for reconsideration that might be filed contemporaneously, what is a remand to the examiner and when might that apply? What does it mean that the record is locked on appeal and you can't add new evidence? When does it apply that the appeal could be suspended pending the possible cancellation of a registration or pending some other event that might be eligible for suspension of the appeal? In an inter partes case, the following terms and concepts are important to know about. What is an opposition versus a cancellation, and what are the meanings of those terms? What are extensions of time to oppose, and what are the requirements for them, and how long do they last? Who has the burden of proof and persuasion for various elements in the case? What are the pleading requirements? That's generally going to be the initial complaint, notice of opposition, or petition to cancel, and the answer, and when can they be amended or supplemented? What are the standing requirements, which now is called entitlement to a statutory cause of action, an important threshold to move forward with a case? How is discovery conducted? What are the elements of discovery? What is the timing? Just within the world of discovery, there's several other things we could talk about, but discovery is an important concept. One of those other tools is depositions. When might a deposition take place? What are the rules for noticing and conducting a deposition? That could be a discovery deposition or a testimony deposition. What types of motions are available in a TTAB inter partes case? That could be motion to compel, motion for summary judgment, motion for extension of time, with consent, without consent. There's a myriad of motions that can be filed. What is the protective order? What does that govern? How does it work? What does it say? What are the requirements? How can it be amended in certain circumstances? An important concept to know in a TTAB case. What is testimony and how does that work? That's like the final evidence presented to the court or the board in this case, which is again separate from the discovery process, but very much related. What forms or types of evidence are acceptable as testimony is important to know. And one of those is declarations. And how do declarations work? When can they be used? How can they be used? And why are they an effective tool? And what things might they not be able to effectively cover? Last but not least, an important tool in the inter partes case of the TTAB is what is ACR, or accelerated case resolution, which could be the parties agreeing to some ways to streamline or speed up or change the rules or procedures in a case in hopes of bringing about a quicker or easier resolution or settlement. So that was a lot about TTAB terms. Believe it or not, in some ways that was just scratching the surface. TTAB is very, very complicated litigation. If you have any questions about a TTAB case, we have more resources on our website, or you can reach out to us on our website at ericpelton.com. You've just listened to another episode of Tricks of the Trademark with me, Erik Pelton. For lots more episodes, videos, content, links, blog posts, and more, visit our website at www.ericpelton.com.